All right, we'll probably have a few more people join, but I know we have a lot to cover, and I appreciate you all being on this call today. I'm Lori Higgins, president of the MetroNorth Chamber, and we are very pleased to be able to offer you this webinar today to give you some information about the Paid Family Medical Leave program starting in January that will pretty much impact every employer and every employee in the state of Minnesota. I'm aware that it sounds like my audio might not be the best. I apologize, but the good news is I'm not going to be talking that much today. We've got some wonderful experts here who are ready to dive into their presentations and give you the information that you're waiting for. So without further ado, I'm going to turn it over to Nate Allen so he can introduce himself and tee up what we're going to cover today and then dive into his portion.
Yeah, thanks, Lori. My name's Nate Allen. I'm an attorney at the law firm of Grease Lenhart Allen. We've got offices located in St. Michael, Blaine, and Bloomington. So the topic today is Minnesota's new Paid Leave Act. We are going to do our best to summarize this for you. It'll have much more of an employer spin on it than it will for the employees today. So please know that at the outset that this is a new law. We're all learning it together. It's quite detailed, and it kind of took everybody in my world a little bit by surprise that it's actually going into effect this year, or I should say January 1st. We thought it might get kicked out again, pushed back, or even repealed or modified. But here we go, and we're all scrambling to try to make it work. So we're not going to get into every detail today. There's already day-long presentations on the topic. We obviously don't have that much time, but we'll do our best to summarize the key parts of it and hopefully generate some discussion and go from there. So if you do have questions, my understanding is that people's audios are not on. So please utilize the chat box, and we'll try to answer questions as we go to the extent we can as they come up. So I'm going to try to share my screen. Got a few slides. Hopefully that looks okay.
Looks great.
All right.
And if I can, Nate, as you're teeing things up, so we'll go through the overview of the program, then we're going to talk about some insurance options, and then we're going to end with HR and compliance. So put your questions in the chat as you have them, but we'll try to put them kind of in those three buckets as we go along. So if you have a question right away on insurance, we'll probably wait until Kevin's presentation so that he can answer that. But feel free as you think of things to put them in the chat, and we'll do our best to get through them all throughout the presentation.
Sounds good. Thanks. All right. So Minnesota's paid leave law, like I said, we didn't know that it would. We shouldn't be surprised that it's here because it was originally passed in the 2023 legislative session. It does go into effect on January 1st, 2026. But there are some requirements that employers need to be aware of before then. We'll get into that in a little bit. So payments generally under the plan are going to be funded through a new department from the Department of Economic and Employment Development, which is DEED. You'll hear a lot about DEED today, probably, if you probably get used to going to their website. They're going to administer the program through the Family and Medical Benefits Division. So payments are going to be funded by a combination of premiums that employers will make. The employer is going to pay some part of that, and the employee is going to pay some part of that. We'll talk a little bit about how much and what that means for everybody as we get into it. And then unless you're using an alternative plan, which we'll also talk about today, Kevin will get into that later, DEED will ultimately determine whether or not employees are eligible under the plan. So essentially, employees get two different types of leave. And this is an important distinction. So I've kind of broken it out onto this slide. You can read through it, but I'll kind of go over it. Employees are eligible employees are offered up to 12 weeks of paid leave under medical leave and 12 weeks of paid leave under family leave. However, they can only use a combination or a total aggregate of 20 weeks per year. So the medical leave is essentially leave that's used by an individual for their own serious health condition. And there's a definition for that. And that includes care that's related to pregnancy, childbirth, and recovery from childbirth. So I don't want to go too deep into the weeds with you on this, but for the most part, a serious health condition is defined as a physical or mental illness, injury, impairment, condition, or substance use disorder that involves inpatient care in a hospital, hospice, or residential medical care facility, or continuing treatment or supervision by a healthcare provider. There's a few other details there, but essentially that's it for the most part. So family leave, on the other hand, is a little bit more expansive. So we've got it laid out there. There's bonding leave, military leave, family, or what they're calling caring leave, and then safety leave. So I'll go through a couple of them. The bonding leave is to care for a new child, whether through birth, adoption, or foster placement. Military leave is to support a family member called to active duty. Safety leave is to respond to issues related to domestic violence, sexual assault, or stalking for the employee or a family member. The care leave is to care for a family member with a serious health condition. So that serious health condition definition is the same as it is for individuals. But you need to understand that the definition of a family member in Minnesota under this new act is extremely expansive. And I'm going to go through that list with you. So a family member under this family leave includes a spouse or domestic partner, a child, including a biological child, adopted child, foster child, stepchild, a child of a domestic partner, or a child who the parent is the legal guardian. It also includes a parent, a sibling, a grandchild, a grandparent or a spouse's grandparent, a son-in-law or daughter-in-law. Any individual has a personal relationship with the applicant that creates an expectation of reliance that the applicant care for the individual without compensation, whether or not the applicant and the individual reside together. So if I want to say, just kind of go through that real quick again. So for the most part, it's, spouses, domestic partners, parents, children, but this idea that it also includes any individual who has a personal relationship with the applicant that creates an expectation of reliance on their care. So you can kind of understand that it's a very expansive definition. So who's eligible for coverage? I'm going to skip this slide and come back to it. Minnesota employees, and this is kind of a weird part about the law, is it looks back a lot. So it's workers who spent at least 50% of the previous year in Minnesota, or workers who lived in Minnesota and did not work in any other state, any one single state, for at least 50% of the year. So it generally covers all private and public employers, excluding the federal government, and self-employed individuals and independent contractors are also excluded, but they can opt in under the program. You kind of see under this graph, there's a little bit of a longer list. I'll just leave it up for a second as you kind of gather through it. So there's employees who are not covered but can and cannot opt in, those who are not covered and can, and then who is also covered. So in addition, the benefits allow for eligible employees to receive approximately 90% of their wages if they've earned at least 5.3% of the statewide average annual wage in the prior year. Again, this idea that it's looking back, which for 2026, it's not a lot of money. It's $3,900. So it's not going to take long to get there if you think about it. So there is the benefit amount is up to 90% of regular wages with a max of $1,423 per week. That will get reset. And that's something that they'll redo each year. All right, so employers and employees share the cost of these premiums. As it sits right now, for most employers, that amount is going to be 0.88% of covered wages. Small employers, which may include most of you out there, is 30 or fewer employees, do get a reduced rate of 0.66%. And in order to be eligible for that, not only do you have to have 30 or fewer employees, but your average employee wage must be less than 150% of the statewide average weekly wage. So the employer is obligated to cover at least 50% of the employee contribution, but can cover more. And if the employer does cover more, it will change the tax on it a little bit, depending on whether or not it's medical leave or family leave. And I'll get into that in a little bit here. So the first premium due date, note April 30th, 2026, but wages must be collected starting January 1st. So again, be prepared. Premium rates I talked about will be reset each year in July by July 31st for the following year. And right now there's a statutory maximum rate in the law at 1.2%. So that 0.88% and 0.66% is anticipated to go up or may go up. But right now it's capped at 1.2%. And I have talked to a few people that think that in order for the program to work, that the 1.2% is actually going to be deficient to support the program. So we'll see how the economics work out once we get into it. The paid leave benefits can run concurrently with other laws such as FMLA and the Minnesota Parent Leave Act. However, it's worth noting that you cannot force employees to use PTO or ESST with it. They can supplement it or top off if you have a program or a policy that allows for it with those things, but you can't force them to use those in advance. So another thing to consider is that because it can run concurrently, but doesn't necessarily run concurrently, we are recommending to all of our employer clients that they review their policies to prevent something called stacking, which is going to be the unfortunate combination of all of these leave benefits that continue on and on and on and on. So it's really important that every one of you address your policies to prevent that from happening. Something to think about before the end of the year. Employers are also prohibited under the Act from retaliating against employees for applying or utilizing benefits. This includes discharge, discipline, threats, coercion, or any form of discrimination or retaliation. Employers must continue to fund the employer portion of the premiums while the employee is on leave, and they must generally restore employee to their position prior to leave or an equivalent position. Now those protections of restoring their job don't take effect until 90 days after their date of hire. But it is an important thing to note. There are some exceptions to that rule. I won't get into them today. If you have questions, we certainly inquire about it. It's important to note too, I don't know how DEED's going to actually enforce this, but it does have in the statute that they may impose penalties on the employer from $1,000 to $10,000 per violation. So quickly, I'm going to go through the tax considerations kind of at a high level. So if you do have questions on this, reach out to your accountants. But generally, premiums are collected on post-tax wages, and employers can deduct their required premium contribution as an excise tax. If the employer does pay more than the 50%, they can deduct that as an ordinary business expense. For the employees, any portion of the premium they pay is treated like ordinary wages, and it shows up on their W-2 and does not lower their taxable income. However, if they use family leave, that's treated a little bit differently, and those benefits are not considered covered wages and are not subject to employment taxes and are only reported as income. Right. So what do you need to know and what do you need to do now? There's a couple of key dates coming up. There are 2 required notices that must be given. Right now, that deadline is December 1st. So you got a little over a month. One of them is a required poster that you must post in a conspicuous place. A conspicuous place. And that poster is available from the deed website, and I think Lori and the chamber will make that available to people as well. In addition to that, you have to give an individual notice to each employee, and that individual notice also needs to be given by December 1st, or within 30 days of an employee's start date or before deductions begin. So if you hire people after December 1st or into next year, just remember they need that additional individual notice at that time. I've got a list of some of the things that individual notice includes, such as an availability of the benefits that are provided under the Paid Leave Act, the amount of the premium deductions the employer will make, the name and mailing address of the employer, the ID number assigned to the employer by deed, and instructions for how to file a claim. The failure to give that notice, individual notice to employees, can result in a $50 to $300 per violation. I do want to also just note, and it's kind of hard because of the webinar nature of the presentation today, but I think it's important to note for people, if you're wondering how do you give that individual employee notice, it says the statute is kind of unique, but it says delivery is made when an employee provides written or electronic acknowledgement of receipt of the information. And in cases where the employee refuses to acknowledge receipt, the employer must be able to demonstrate the way the employee had been notified. So a lot of clients have been asking, does this have to be something they sign? And the reality of it is it's not, but it is something they need to acknowledge, or you need to prove that they or how you distribute it to them if they don't acknowledge it in some way, shape, or form. So as for the employees, if they're going to be utilizing it, the statute does indicate that when foreseeable, they're supposed to provide at least 30 days notice to the employer, but obviously that's not always practical. And in such instances, it should be given as soon as it's known. So with that, I'm going to turn it over to Kevin to talk about alternative options to the deed run program.
So before we turn it over to Kevin, just two quick questions for you. Nate, are you willing to share these slides with attendees?
Sure.
Okay, fantastic. I can get those out to those who are registered. And then the second question we have in the chat, what kind of documentation must the employee provide for proof of leave, and how is the length of leave determined?
So, well, let me answer the second part of that. The proof of leave, there will be a notice that deed will make a determination. So my understanding is that the employee will make a request for benefits to deed directly, or if not to deed if there's an alternative program to the insurer, which Kevin can talk more about. And then there'll be some type of a determination that they get. And I forgot to mention, I should say this. The program is going to be run in collaboration with the unemployment benefits. And so I think for people that are kind of nervous or scared about it, it should hopefully kind of work through the employer a lot like unemployment, right? We make contributions, or employers make contributions. Employees make the application for benefits, and then employers get notice of it. There's an opportunity to actually respond. There is a provision or some provisions in the statute about how to appeal it. So those are some of the things that we're going to have to work our way through. I think Patty's maybe can provide some additional information. She's been involved in other states that have done this. If she wants to chime in too, that'd be great.
I'm trying to find my buttons so I can get on here. Yes, you're right. You're going to file for the state for this time off. That they'll ask for supporting documentation, usually from a medical care provider. The fact that the mechanism for taking the deductions has already been set up by the unemployment department, so we can continue to make contributions, collect the contributions during the beginning period and submit them at a quarterly level. One important thing to note, we have some employers who do not pay into unemployment, typically some religious and nonprofit organizations. You are likely still covered by this law. So if you don't have unemployment deductions being taken and submitted, that's something that you'll still have to set up, and it likely still covers you.
Thank you. And then one other question came into the chat that I think, Nate, is probably in your area. Is there a specific individual notice provided by deed to give to the employee?
There is well, there's not a specific notice, but Deed does have a sample available on their website already. I think it came out about a week or two ago. I can certainly provide a link to that from the chamber. Otherwise, if you just search on the Deed website, they do have a summary of that individual notice and a sample that each employer can tailor to their own. It's a Word doc that you can download, put on your letterhead, and provide to your employees.
And then can you explain in further detail how this will affect seasonal businesses?
Well, that's a good question. See, there is a definition and some application and exceptions under the statute for seasonal employees, but it defines a seasonal employee as an individual who is employed for no more than 150 days during a consecutive 52-week period in hospitality by an employer whose average receipts during the previous 6 months were not more than 33% of its. I mean, the definition is a little bit convoluted, and it must be tied to hospitality. So I think for example, I've gotten a couple questions, and we're still working through the analysis for, say, like a golf course employer that only has people there from April until October, and so we're kind of working through some of the timelines and whatnot, because they're certainly not in the hospitality industry. So we're still working through those definitions. I saw the one here. Does it apply to business owners with no employees? I think you need to have employees. If you are self-employed, as I mentioned, maybe glossed over this, but if you're self-employed, you're excluded, but you can opt in. So there's a mechanism on how to opt in for self-employed and independent contractors.
Right. Thank you. So it looks like there's a pause in the chat right now. So this is probably a good time to turn over to Kevin so he can talk about insurance options.
Thanks, Lori. Thanks, Nate, for the intro. It's great having somebody else be able to explain what paid family medical leave is from a lawyer. I am not a lawyer. I don't pretend to be one, so this is not legal advice that I'm giving you. If you want that, Nate's here for you. It's also not tax planning advice. All right. My name is Kevin Krasa with TKA Health. We are a boutique employee benefits and health insurance brokerage in Coon Rapids. Today, we're going to talk about the coordination of benefits between paid family and medical leave and the other employee benefits that you have through your workplace. First and foremost, interaction. So there's a need for updating your benefit strategy based on the timeline that paid family and medical leave covers employees. Nate talked about the 12 weeks for family leave, 12 weeks for medical. You can't be over your 20 weeks in a year, whether it's calendar or you're choosing 365 days rolling. What does that mean for short-term disability? What does that mean for organizations who top off? I'm sure Patty and the team at TriNet are going to talk about, FMLA and things like that, that make all this coordination very exciting. I will tell you the time to determine your benefit strategy is now. Nate talked about a couple of deadlines, first being November 10th for the equivalent plan exemption date. It's actually sooner than that. So in order to quote with any carrier that's remaining in the state of Minnesota, they need that quoting information in by Friday at midnight, actually 11:59 p.m. So every carrier is cutting off quoting as of that time because they cannot guarantee with the volume of quotes they've received to return back application and then completed product information by November 10th. I'll tell you again, Friday at 11:59 p.m. All right, on from there. There are some differences in the state and the private plan. The state plan is in and of itself almost like an insurance plan, right? We're paying into a pool of money. That pool of money then pays out to the people who are drawing against it, right? If you take leave, you're not paying as an employer. You're banking on the state having the funds to pay your employees so that they can take leave. The same way it works with a private plan. The administration is a little different, right? The administration comes from the state of Minnesota, who's nearing completion of their hiring process. I give them kudos. They were, quite far behind in August, and they've caught up pretty well. The private plan, Minnesota is the 13th state to do this, to enact paid family and medical leave. And the carriers that we work with, of 17 of them, I know for a fact that at least the 12 that we have work in every other state. So they've got experience navigating these policies. Approval process. It's I have automatic there. There's an application process or submitting supporting documentation. You're going to call in for your claim, and it will be somewhat similar to the private carriers. The state plan will have their process. We're not exactly sure what that process looks like yet and how identical it will be to the private carriers. We know from the private carrier side that, for example, medical leave, you'll need doctor's notes. Obviously, family leave, if you're taking it because of a birth of a child, you're going to need, birth certificate or social security number, hospital invoices, things like that. The one that we know will happen through private carriers is the documentation for family leave, taking care of a family member, or somebody who has material impact on your life. You will need a doctor's note from their attending physician or primary care provider, not from you. So there are guardrails in place to prevent abuse that way. On to premium cost. As Nate mentioned, the state standard rate for 31 or more employees or whose average wage is above 150% of the state average weekly wage is 0.88% of total payroll. For those who qualify for the small employee exemption, it's 0.66. Here's the biggest difference between the state plan and a private carrier. Private carriers are underwriting employers individually. So we require a census from each employer. You need names, date of birth, gender, job title, wages, and then zip code of the business. Not as applicable to each person, but it will vary by plan. We've seen rates go as low as 0.41, and we've seen rates as high as 2.67. So there's quite a bit of variability in the rate factor. What we do from there is once we've gathered quotes from all applicable carriers, we'll advise that employer one way or another, whether it's best to be on a state plan or a private plan. One thing of note, if you start with a private plan and you move back to the state of Minnesota, you are locked in with the state of Minnesota for 3 years. Okay. You cannot leave for 12 quarters. I want to be very clear with that. Regardless of the rate change that the state makes. Okay. They want to be able to recollect the premium that they have missed from there. In addition to that, compliance oversight is kind of managed by the state. There are still things that Nate talked about and Patty and the TriNet team will talk about that you need to do individually as an employer to be compliant with these rules and this law. And then last but certainly not least, there's an application fee. There's no application fee for the state of Minnesota going with them, but if you're with a private carrier, the application fee will be anywhere from $250 to $1,000, depending on the size of the business. My guess is that most folks on this call will be in the $250 range, with maybe a couple here being in the $500 range. Before I move on, I saw we had some questions in the chat. I just want to make sure I didn't miss anything.
Do you want me to read them out loud, Kevin, or can you?
Yeah, I'll send out slides.
And we're all recording this as well, but we'll get this recording out to everyone afterwards as well.
Okay. Just want to make sure I'm not missing anything.
No, there is a
All right. Coordinating PFML with your existing benefits. PTO and ESST use, Nate spoke perfectly about this. You can't force employees to use this. You can't force employees to use short-term disability prior to using paid family and medical leave. PTO and short-term disability can be used concurrently with paid family and medical leave, but they cannot be used in place of to start off. All right. If you tell an employee that you have to use something else before paid family and medical leave, you are not being compliant. You're going to get slapped on the wrist pretty hard. There are provisions in some carriers' policies, private carriers' policies, that you can use short-term disability to potentially top off paid family and medical leave earnings. We don't typically recommend that happening, but it is possible. Okay. Typically we want them to run concurrently and not be used as a top off. For those that have higher earning folks, using a short-term disability policy will greatly enhance the benefits that their employees see based on the threshold of pay that is given, that $14.23 per week to those employees. Right. Integrating paid family and medical leave into your benefits. At the base, we've got, paid family and medical leave. It's required by law. You have job protection and you have wage replacement. It's up to that 90% wage replacement, depending on the wage of the employee. Roughly that 32,000 and change dollar will get you in the 90% range. Then we have internal leave policies. Patty will talk about internal leave policies and how they affect paid family and medical leave, and your communication plan as well. And then we get to the supplemental benefits, which are really on top of, both of these items. We need to offer short-term disability for reoccurrence. Reoccurrence outside of the 12 weeks for potentially medical within a year. If you don't have that, you are SOL. You're not included. You won't have any additional protection for your employees to earn wages while they're out of work. Similarly, changing your short-term disability policies to have elimination periods that are long is also going to be detrimental to your employees. We've heard in the beginning, not the beginning, but March, April, May of this year, we ran into a few brokers who had the 90-day elimination period for short-term disability, and this just significantly hampers an employee's ability to earn money while they're not able to work after they've used paid family and medical leave. So really the coordination of those short-term disability policies and matching them up with paid family and medical leave are critical. When we talk about, whoops, I didn't even switch slides. Sorry, guys. What you should be doing now. We need to set up, if you're thinking about going with a private plan at all, we need to talk as soon as possible. Like I said, the deadline is Friday at 11:59 p.m. That's when I have to have this information to carriers. They won't even quote us for a January 1st effective date after that. After that time period, you're looking at an April 1st effective date. So the end of Q1 in Minnesota. So you'd be automatically put onto the state plan. Once we submit the census for quoting and you get the quote back, we'll have a conversation about deciding between state versus private. You know, what really makes sense for you, your business, and your individual situation. Next, determining employee contributions. How much do you want employees to contribute to their leave policy? Is it, you know, half of that premium? Is it the 0.44%? Are you willing to shoulder the brunt of that financial burden? And then updating your policies and communication plans. I'm sure we're going to hear from Patty about how communication is key through all of your employees in what's coming up. How can we support you? Really, it's full soup to nuts compliance, disability coordination, other benefit coordination, and really being there as a trusted partner for you moving forward. And then if anybody has any questions about it, post this meeting, please feel free to give me a call. I don't really have anything else for the insurance side of things. Thanks, Lori.
Of course, and so we do have a question in the chat I want to throw out there now. So can you clarify that any person who receives a W-2, including sole business owners with no employees who file as an S corporation, are included in this plan? And does it matter if the owner is not currently participating in the state unemployment program?
So Patricia here, I'd like to comment on that. I cannot, I don't make the determination on who is covered, but I will say that the state is saying that people who paid a W-2 who make a certain amount, 5.3 of the state's weekly wage, are covered. But I do know that their unemployment participation or lack of participation does not dictate if they are covered. So if I don't pay into unemployment, that doesn't mean that I am not covered under this program. They have very conveniently, the state, DEED, has very conveniently made contributions follow the same routing as unemployment, but in the absence of unemployment, there's still a route to make these payments and these contributions.
Yeah, this is Nate. I'll maybe dive in on the first part of that then. So an employer under the statute is a really expansive definition. But it includes any type of organization, individual, it even includes trustees and bankruptcies, receiverships, anybody that has any individual with covered employment working underneath them. So the question really has to be analyzed whether or not that covered employment exists. And if it does, then you are going to be required to participate. And again, we went through this at the beginning, that covered employment means that you have to have performed 50% or more of your employment during the calendar year in Minnesota, or not in any one other individual state. And it does not include self-employed individuals or independent contractors or most employment by seasonal employees, unless the independent contractors or employers opt in. And so if you're a self-employed individual and you get a W-2, there is a process by which you can enroll in the program. It's a little bit more in depth and probably a little bit beyond the scope of this, but if that's something that's relevant, it's certainly worth talking to somebody like Kevin about, or maybe me, and we can dig offline on how to go about including yourself into the program if it's something you want to do. There's a process by which you have to estimate your self-employment income, and so it's an opt-in, but otherwise you'll be generally excluded.
Okay, now we've got two more insurance-related questions that we should address here while we're still on that topic with Kevin. So if we miss the October 24th deadline for private carriers to quote January 1st, and the next time we can quote is for April, if that happens, we are to enroll with state program. However, I thought if we were in the state, we're locked in for 3 years. So can you clarify?
Yep. So if you start with the state program, you're not locked into anything. So you could change it any quarter. They're offering enrollment opportunities at the end of the previous quarter, beginning of the next quarter, for each quarter of the year. So you are not locked into the state for 3 years until you go to a private carrier and then attempt to come back or do come back to the state of Minnesota.
Okay.
Hopefully that answers that question.
And then why would someone choose the state plan or the private carrier plan?
Great question. A lot of it will come down to rates and experience. And the rate, seemingly similar rates. There are a lot of insurance carriers buying at, 7 to 10 basis points underneath the state rate. So if you have a large payroll, or a particularly high incidence of folks taking leave, and you can get a 2-year rate lock, that would be a really great way to protect the business from experiencing additional tax in the next year. And then for experience, it really relates to your employees' experience filing claims and how those are handled, both on their level and then your hand-holding, for lack of a better word, through the process, right? As a private carrier will help you through that process. You'll have dedicated account representatives to say, hey, I have questions. Here's what I need to be doing, versus calling the state of Minnesota and attempting to ask the same questions.
Thank you. All right, it looks like we've got a couple of questions that might be addressed under TriNet's presentation. So I would like to turn it over to Jackie and Patricia from TriNet to start their presentation. And then if these specific questions aren't addressed, we'll do those first off as we go through the next round in the chat. So thank you, Kevin, for that. And TriNet, if Jackie and Patricia, you can introduce yourselves, that would be fantastic.
Fantastic. Thanks so much. I'm Jackie Breslin. I am TriNet's Executive Director of Client HR Consulting, and I focus on a number of different things, but definitely compliance and watching the regulatory landscape. And so keeping our clients up to date with what's new and changing. Then I'll turn it over to Patricia.
Hi, I'm Patricia Quattlebaum. Somebody keeps referring to somebody named Patty. I don't think that she has joined the meeting, so I'm going to speak for her just in case. I know this represents a very big change to businesses and employees in Minnesota, but state of California started this back in 2004. TriNet has lots and lots of experience in helping clients through massive changes like this and adjusting to it. And I know when we get to the other side, you're going to feel better. I know it's a tax. I know there's a lot of laws. I know there's a lot to adjust to, but ultimately this gives your employees opportunities to take time off for some significant life events and then come back and be happy, productive employees. At least that's the goal.
Fantastic. Just trying to share my screen here. Okay, great. Can you see my screen okay?
Jackie, I'm just seeing your name, but not your picture or a slide.
Okay. Let me try again here. Sorry about that.
And if it doesn't work, I can try to bring out the deck.
Okay, let me just try one more time. I'm not having the best computer luck today.
How about that?
Okay, we can see your screen. Thank you.
Okay.
Okay, great. So thanks so much. So just a little continuing down with some little bit of background about TriNet. So we provide small and medium-sized business with full service HR solutions. So Patricia and I have the advantage of talking to clients about this topic and other HR compliance topics, all the time. We can go ahead and go to the next slide. So I'm imagining by this point in our session, you feel like you're trying to put the paid family and medical leave puzzle together. And we absolutely understand the feeling. If we think about the time that we're spending, Patricia and I, trying to help our clients solve HR complexities, it is our entire day, all day long, all week long. And so we're going to review some suggestions of really like practical ideas about where to focus from an HR practitioner's perspective. And and we'll talk about some more about the required communication, the notices, policy development, manager training, workforce planning, plus how this fits in with your current time off programs. And our hope is that we'll provide you with some practical tips so this feels like less of a puzzle after Patricia and I are done talking. We can go to the next slide. And I'll turn it over to you, Patricia.
Great. Thanks, Jackie. We have gone over this on the compliance end, but just from the HR best practice end, it's always important to communicate details about changes in laws, benefits, and policies, anything that's going to affect your employees. In the case of this paid leave, it's not just important, it's required. As a starting point, as Nate mentioned, you're going to need to display a physical, or in the case of remote workers, an electronic poster that provides details on paid leave rights and benefits. Your employees need to know what they're eligible for. These posters are available right now in multiple languages on Deed's site. Next, by December 1st, and within 30 days of hiring a new employee, you want to provide written notice to your employees. There are sample notices already available on the site. An important detail is that these notices are required to be acknowledged by your employees. And Nate, I remember you touched on this. It means you want to keep a record of their signatures or their electronic acknowledgments. For TriNet colleagues, clients, or those who have an HRIS system, those notices can typically be added to a platform. You can have acknowledgments made. Employers can run reports that show each of these acknowledgments so that you're able to substantiate that they have been acknowledged. Nate mentioned also that an employee might refuse to acknowledge, and then you have to track their refusal. When you have them online, there's an easy way to show that. I don't really get the purpose of that. I'll sign a piece of paper saying I won't acknowledge it, but that works for me too. The required notices include information about employee contributions to this paid family medical leave. Given that this is a new deduction for your employees, it's something that they need to adjust to, and it's important that they understand ahead of time that they're going to see these deductions from their pay beginning January 1. As we discussed earlier, these deductions can be as high as 0.44% of the state's cost. If you opt into a private plan and different costs may apply, those costs cannot exceed that amount, whatever that might be, and it will change over time. And then here's a big one. On top of communicating, we want to train your people managers on what is involved. So as Jackie's described, you've been putting together the PFML puzzle, maybe starting with the edge pieces and then working your way in. Come January 1, you'll have significant roles and responsibilities, not just in allowing, but aiding your employees in accessing this paid leave. Training people managers and supervisors on how to respond to an employee's request for paid leave is a very important piece of the puzzle. Paid family medical leave entitles your employees to take this time off with benefit protections, job protections, and protections against retaliation or discriminating for requesting or obtaining benefits under this leave. That's where the training comes in. People managers want to be consistent on how they respond to these requests. The best way to do this is to follow the policy that you're going to spend time creating, making sure managers don't voice concerns about the need for the leave, the timing of the leave, how using this leave is going to affect this business. In other words, not the emotional response. They need a planned response. And that's because your employees are entitled to this leave. Sometimes this takes practice. It's natural that as a manager, our first instinct might be to think about the logistics of somebody leaving for a period of time. It can be helpful to script how managers will respond to these requests. It can be as simple as saying, when somebody asks you this, you say, thanks for letting me know. And that can be a good start. You then continue down the next step by following your written policy, and Jackie will touch on that in just a minute, and then continuing whatever forms and information they're going to need to provide to substantiate the need for this leave. Another important piece of the puzzle is having a plan for how your employees will return to work once the leave has been covered. There might be other laws that come into play. The one that comes to mind is the Americans with Disabilities Act, and that might need to be considered in the event that your employee who has exhausted their leave under the Paid Family Medical Leave Act might also be eligible for additional time. So we want a policy and a plan and a response from your managers when that comes into effect. Jackie, if you wanted to touch on the policy development.
I do. And it's interesting because my Friday afternoon ended with questions about drafting policies, and my Monday morning started with questions about, drafting this policy. So it's really perfect timing. And as January 1st, 2026 is rapidly approaching, prioritizing preparing a compliant policy is so important. And while the law is detailed and prescriptive, there are still decisions that you must make that need to be communicated within the policy. And the policy really becomes like the North Star on the topic, as employees will read it to understand what their rights are, and managers will count on the policy to help them navigate requests for leave. So, as Patricia just described, our managers play such an important role, in the compliance of this program. And so, having a policy that is well articulated and then training managers on this policy is super important. And policy creation is complicated. So no wonder, right? My inbox was, as I ended on Friday, had questions. Monday started with new clients with new questions. It's a good time to seek support from an HR professional or legal counsel on getting this policy right. And you wanted to start by defining who's eligible for this policy. If you're a multi-state employer, this is a key piece to the policy for any reason, but especially if you have employees from different states trying to figure out what's applicable to them when it comes to paid family leave. Make that very clear right off the bat. And the policy must clearly define the types of leave covered under PFML. And it's, for example, it can be taken for an employee's own serious health condition, caring for a family member with a serious health condition, bonding with a new child, and that can be birth, adoption, foster care, safety concerns like domestic violence, military related leave. There's a lot of reasons. And so making that clear is important. And then also describing the leave duration. So it could be up to 12 weeks of medical leave or 12 weeks of family leave per year. Describing the combined total can't exceed 20 weeks in a 12-month period. Those details are also important. You also want to describe the job protection and wage replacement benefit. So while qualified leave must be job and benefits protected, you also want to give direction to employees regarding how they apply for the benefit in order to be compensated through the program. It's pretty interesting the number of employees who miss that step. I know it sounds logical, but employees either miss deadlines or don't complete all the pieces that they need to apply for the benefit and are caught off guard when they're not receiving compensation that they expect. So make sure there's clear instructions about what the employee responsibilities are. And then if employees are currently contributing towards their health benefit premiums while they're actively working, how will those share of premiums be reconciled? So if they still owe premiums for their benefits, how will that be accomplished? So clarifying that can be an important part of the policy, but is also something we see frequently overlooked and not spelled out well in policies. And then also explain in the policy how PFML interacts with other leave policies. For example, how will it interact with federal FMLA, Minnesota Earned Sick and Safe Time, your paid time off program, and any other internal leave programs that you have. And while not required, some employers choose to pay employees additional money on top of what they're receiving from the PFML program and to get them closer to their regular salary. This is an employee retention strategy we see with some of our clients, and it has momentum, especially with competitive industries. Um, so if that is something that you're going to be thinking of doing or you do now, you'll want to incorporate that into your policy also. It's also important to direct employees on who at the company they communicate their time off request to and the timeline. 30 days notice is great or as soon as possible, but time off in these scenarios may come up unexpectedly, which can be frustrating, but it's not an automatic reason to deny the request. As Patricia talked about, we don't want managers just saying, no, can't have it. You didn't give me the right level of notice. It's really important to communicate what the notice period is, but you also have to have some flexibility as these time off for these reasons can come up unexpectedly. So once you go through the painstaking process of policy creation, be sure to distribute that policy for employees to acknowledge. You want to maintain the policy in a location that's easy for employees to access, and be sure to maintain the employee acknowledgements. I was recently reminded of the long laundry list of items that need to be produced when there's a claim of noncompliance with PFML or paid sick leave laws, and demonstrating that a policy was presented and acknowledged was an item that needed to be is part of that audit. So double check your document retention policies, as you may want to consider amending them, as the paid leave law requires paid leave records to be maintained for 6 years. So if that's not what your retention policy says, you might need to make some edits to that. And last but not least, be ready for change. Changes to the law may mean needing to update your policy. Therefore, be sure to watch this topic closely and make changes to your policy as needed. Okay, go ahead to the next slide. Let's talk about workforce planning. And to help you prepare for employee absences and ensure compliance, we'll want to look at a couple of practical tips to get prepared. And a new paid, as this is new, it may bring up various reactions. And you may see this as a way to attract and retain talent, or that it adds a sense of security for your employees that doesn't exist now. Or you may be worried that employees will be taking more time off than they are currently or prior to the program being in place. And that can have a sense of pressure on managers and coworkers and disrupting client relationships and increasing costs. So there can be a mixed feelings that are going on for all of you on the call today. So one of the things to help us feel better about the pressure of what might be coming is to assess what your workforce needs are now. Like, take some time to identify critical roles and consider cross-training employees. Early planning can minimize disruption when employees take leave. And you also may need to go back to the basics here. For example, do all employees have current job descriptions? Are managers tracking pending projects, commitments to clients, vendor relationships? You want to challenge your managers with the question, if one of your directs had to take a sudden, unexpected multi-week leave of absence with little to no warning or time to train or delegate their work or communicate with them while they were on leave, if that wasn't possible, what impacts would occur? Are all the right, IT protocols in place? Are documents back up in a central location to access? Are client contacts up to date? Are there strategies managers need to be doing during one-on-ones right now to make sure they understand their team's responsibilities in a deeper way? So managers can be planning now how they would delegate work if an absence occurs for the hypothetical or in some cases the inevitable. So now's the time to plan that and think through that. It's also a good reminder to think about the importance of fostering an inclusive workplace culture. And you really want to encourage open communication about leave needs and reassure employees that taking PFML is supported. A positive culture helps reduce the anxiety, improves retention. So taking time off for medical reasons or to care for a family member is highly personal. And you want to make sure that employees are not dreading needing to communicate that they must take time off. It creates situations where employees wait until the very last minute to communicate time off needs because they believe the reaction will be negative and they don't want to work in an atmosphere of negativity. So encourage managers to have an open door and safe space for employees to take and request time off. And then also under the umbrella of preparation, you might want to consider establishing a relationship with a temporary staffing firm. And this can be a way to help cover essential functions during absences. Identify reputable agencies that specialize in your industry, share your anticipated leave patterns, your skill requirements, and company culture with the firm. You could consider negotiating terms and fees, including minimums, overtime, and conversion fees in advance. And this can help with budgeting purposes, and last minute negotiations may not be, as fruitful as getting ahead of something like that. So prepare in advance, thinking through how you will onboard and train temporary staff and communicate expectations. And as you monitor performance of the temporary staff, you can provide, feedback to the firm. It's a way for them to continue to get to know you. Also, you can consider, establishing a relationship with an independent contractors, and just be sure to use the federal economic realities test and any other relevant state tests and federal tests to analyze whether a worker is an employee or an independent contractor under the Fair Labor Standards Act, as misclassification of a worker can be incredibly costly. So you don't want to skip that step. So encouraging some, advanced planning now to get ready for what's forthcoming. Patricia, back to you.
So following that, we wanted to talk a little bit about the Earned Sick and Safe Leave Time, ESST. While the state of Minnesota enacted ESST in 2024, certain cities, Bloomfield, St. Paul, Minneapolis, and at one point Duluth, had their own plans. Like the majority of ESST plans, which many people call paid sick leave, so I see a lot of PSL plans across the United States, time off accrues at 1 hour per every 30 hours worked. Employees are allowed to accrue up to 48 hours in a year and then have in their bucket of available hours 80 overall for their use. This slide shows a helpful breakdown of some of the similarities and the differences in the two programs. Most notably, paid leave under PFML is for qualifying conditions that last at least 7 days. And the pay that an employee might receive under paid leave is provided by the state, which employers and employees have contributed to, but rather than directly from the employer themselves. If you take a look at this chart, and I'm going to have to zoom in to be able to see some specifics, it should break down those two categories. Employers are allowed to permit their employees, not require, but permit their employees to use their sick time to top off some of the earnings that they receive while out under paid leave. And that means they would run concurrently. And so you would take the paid leave and the earned sick and safe time at the same time, rather than extending the length of the leave. When an employee comes back from a leave of absence under the paid leave program, it's possible that they would still have earned sick leave or PTO that they could use if it was acceptable. And again, we had touched earlier on the potential for something like the Americans with Disabilities Act to be impacted as well. And that kind of concludes the HR best practices end of things, but I know we have a lot of questions because I can see them coming in.
All right, thank you. So I'm going to start off at the top here from the last question that came in before you started. What happens if they do not use any PFML during their time of employment? Does anything carry over, or is there any type of payout at the end of employment?
That's a great question. This is a program that is provided if you meet the qualifications, so leave more than 7 days for one of the qualifying reasons, and you're a covered employer and employee. There is no payout, and it doesn't increase with each year. It doesn't decrease if you've not used it.
Okay, so if someone is in their 90-day onboarding period, are they eligible for paid family medical leave?
They are eligible if they are an employee and they're working at least 50% of the time in Minnesota, and they have met the salary threshold for applying, which is 5.3% of the state's weekly wage, around $3,500 this year. However, if they have not been employed for 90 days, they might be eligible for benefits, but they are not eligible for the job protection portion of it. Meaning if I hire somebody in the second day there, they say I'm going out on a leave and I end up having to hire somebody, that job was not protected. They'd have to be with that particular employer for 90 days.
And will their time out of the office count towards time working for my company?
That's an excellent question, and I don't believe so, but I would have to check on that.
And then a couple of questions about payroll companies and software. Are they going to be automatically updating their systems to accommodate for this?
You know, I can't speak for individual payroll companies, but yes, they're going to have to.
Okay. If I had an employee whose wife had a baby last week, are they eligible as of January 1st for 12 weeks of paternity leave?
They are. They are, as long as the leave is completed 365 days after the birth of that child. So I could have somebody who had a baby in June, and as long as they wrapped up their leave before June of 2026, they could be covered. That first year is tricky. We saw that with New York.
Yeah, can I jump in real quick, Lori, on that one?
Yeah, please.
Yeah, so I think it's important to note to the employers out there that it's not necessarily your responsibility to determine eligibility, right? The Paid Family Leave Act is not well, it might seem like this at times that it's a protected time off law. It's really a benefit law. It's something that provides eligible employees who have covered employment for a certain amount of pay while they're utilizing the certain types of leave. So the idea there about an employee, are they eligible? Well, they might be eligible is the real answer, because in order they have to have, they have to qualify for those benefits by they're unable to perform work due to a serious health condition or other covered leave, such as the bonding with a child leave. They have to have met sufficient wage credits, built up in their benefit account from previous calendar quarters. Like, as an employer, just because someone's wife had a baby at some point doesn't necessarily mean that they're eligible for benefits under this new law. And that's not for us or for employers to make that determination.
So if we go through the state plan, are we automatically set up?
No, you're not automatically set up. You need to create an administrator account through the state's portal. You'll have an unemployment insurance account that you log into similar systems, but you still need to determine who's going to be the administrator of your leave account. So there's still action items.
Yeah, there's a process on the deed website to do that.
And we have links to this on our website as well as in our e-newsletters as well, and we'll get you some of this information directly shortly after this call as well. Going back to the questions, do we know if the state will pull these taxes out as a separate line item, or will it be grouped as state taxes?
I don't know the answers to that one.
I can't speak to taxes. I believe it's a separate line item, but just like the way you're going to see unemployment separated out.
Yeah, I'll jump in. So it'll have to be reported on the W-2, and what will become really important on this particular issue in dealing with your payroll services companies is what the employer contribution amount is. So remember, employers must cover up to 50% of the premium, but they can cover more. And if they do cover more, then the tax treatment on those changes. So it's really important for people, if you're, to quickly, and I know this was touched upon, when you're creating your policies or making your decisions or enrolling in a private plan this week, like, to make a determination very soon how much as an employer you are going to contribute, because if you're going to contribute more, that's a conversation you want to have with the people who are handling your payroll for purposes of calculating the taxes for the employer and the employee.
Patricia, I think this question is for you. Did you say that employees can double dip with ESST and paid family medical leave?
Employers can allow their employees to take the benefit that they receive from the state and then use a portion of their vacation or personal days or paid sick leave to top off some of that pay, yes. But the employers have to allow that.
And are these benefits going to be treated as a fringe benefit on their W-2s?
The taxation depends on the leave type and the portion with which the employer and employee are contributing each. So it will be a very case-by-case basis.
This is more of a statement than a question, but maybe some of you can address it, maybe some of the things you've seen in other states. But I'm just worried about coverage for our business. If I have to hold a job when someone just took 2 weeks off and then wants 3 months at the first of the year, that's a huge strain on the company.
Yeah, I mean, that's the risk. And that's one of the, personally, I think that's going to be one of the drawbacks for small businesses is, small employers is the coverage issue while they're gone is going to be tricky. Remember, this isn't a 12-week period to be gone. It's a 1 to 12-week period to be gone, up to a maximum of 20 during any year or benefit year, if you will. So, the comment was made, I think Jackie made it during during her presentation that now might be the time to talk to staffing agencies, right? Like it's really going to get tricky for employers to find people to fill positions while people are gone, especially if it's a situation where they're not able to give 30 days advance notice of utilizing the benefit.
And then Patricia and our Jackie, who do you recommend to contact to get this policy written up?
Well, if you're not a TriNet client, I would say go to your legal counsel or an HR consultant to get assistance. And as soon as possible, because the level of detail that needs to go into this policy is going to take you some time to pull it together.
Okay. Do employees on leave automatically retain their medical and other ancillary benefits? Can we require that they reimburse those premiums upfront if they are a payroll deduction?
And that can be laid out into policy. But yes, you can ask them to make their contribution to their benefits as they go because the benefits are protected. Some companies allow people to pay them in arrears when they return, and they allow them to spread them out over multiple payments. I know that's something we help our clients with at TriNet. That's an important part of the policy.
I think I've gotten through all the questions in the chat, so I'm just going to pause while people, oh, there's another one. This feels very overwhelming. What advice can you give on how to make this easier for us?
Yeah, great question. Familiarize yourself with the deed website. There's a lot of great information out there about it. A lot of good handouts. There's some materials about what you can do now or what you should be doing now. They've done a nice job of making resources available for employers. And I would just, if I can, real quick, Lori, there was one question I want to get to. Someone commented that this might be for larger employers and not, small employers. I would gather with the chamber's businesses, there are a lot of small employers on this call and on the webinar. And it's important to note it's one or more employees. If you are a self-employed individual and have a business, you are not eligible, you're not covered, but you can opt in. That's a separate process. So if you have one employee or one or more employees, you are required to do this. If you are self-employed, you can opt in.
Okay. Kevin just shared his contact information in the chat for anyone who wants to reach out to him this week. Okay, what if you are employed and self-employed?
Well, okay, so there's a particular, this is where there's maybe a little more detail than is required, than we want to get into in the next whatever number of minutes. But if you are a self-employed individual, say you have a company and you are the only employee on W-2, there's some eligibility requirements and it's an opt-in situation. So you have to go through a process I'm just trying to flip through the statute in front of me, but it comes down to the analysis of, hang on. Well, suffice it to say that you have to go through an analysis to determine whether or not you're eligible to opt in. So.
Okay. All right, that might require some more offline conversation on those specifics. I'm going to get to a couple other questions here. So in my industry, there will be many that will not return after a FMLA. So getting them to pay for a benefit will be difficult. So is the employer required to keep paying a payroll deduction for health or ancillary benefits? That is not a good position for a business. I really do not expect them to return based on history.
If the employee is separating from the business or employment, then the standard rules apply for whatever your policy is written as. So if you continue benefits through the end of the month after they separate, there's not a requirement to keep paying for health benefits after that time period, or voluntary.
Okay. I know you mentioned that we are not meant to be the determining factor on whether or not someone is eligible for this leave. What happens if someone takes the leave and they are deemed ineligible? What action items do we need to take as the employer? I anticipate it will take some time for the claims to be processed.
So I can speak to the private carrier side. I can't speak to the state of Minnesota side so much. I know there are appeals processes for the private carriers when claims are denied. The appeal process will be different based on the carrier that you are using. And if you end up with a private carrier, that's part of what we help you with, is dealing with that scenario and situation. I'm not going to go into each carrier's policy on how they, do that right now, but if you have questions on it, I'm happy to help.
Okay. And then how much will the employee receive for income if receiving the paid leave? I think we talked about that in the beginning.
And Lori, I couldn't quite hear your question.
It was, how much will the employee receive for income if receiving the paid leave? I think was that one.
Right. The state has a really nice calculator that an employee can go to and look up, and it will say, what did you make in the last 4 quarters? If they worked for more than one employer, they can add those in. So what have you made? And it will do a calculation. I can't figure out the math, but I do know that it can be up to 90% of the state's of their wages, with a top up of $14,000, I believe $23 a week.
Lynn, I just put the link in the chat.
And there's some clarification being sought on the sole owner of a business that has issued a W-2 to the owner.
I think that's very specific to your organization. And I think somebody like Nate, and I see another attorney, Tony, that might be want to reach out to you offline, because I think it's pretty specific to that situation.
Okay. What happens if they resign after they return?
I think this was the follow-up to the question, Kevin, about insurance premiums. And so if you are having the person pay for their insurance while they're on the leave and remit their portion of it, yes, you need to continue it. If you have them pay it back at the end and they don't come back, you're going to have to try to get those monies from them, and that can be very difficult. And so that's part of the policy and part of what you want to think about ahead of time.
Okay, just to be clear, there is still information to come out regarding seasonal businesses that are not hospitality, correct? This law does not make sense for businesses that run for 5.5 to 6 months out of the year.
I completely understand that. Keep in mind that those same people who worked for you seasonally might be working for somebody else seasonally when they need their leave. So the contributions are taking effect, but they might be taking the time off under another employer. And so we don't really know how that looks. There's a look back about how much they have to make, and there's the potential that they are covered, and the state makes those determinations. So, but yeah, I understand that. It's difficult to plan around.
And then do I need to maintain benefits even if the employee is supposed to be paying for the benefits from their payroll?
The state says if they stop making their payments, you can stop that coverage. And I would be so nervous to do that since it's supposed to be benefit protected. And I think that we need more direction from the state and how you would address that.
All right, we have just a few minutes left. Is there anything that our speakers would like to address, go back to, clarify, some encouraging words of support?
Well, I know that we at TriNet would love to hear from you on this and other compliance related topics if you were to be one of our clients. And so I know that we all have a personal stake in this legal end, the insurance end, and the HR best practice end. And we hope to hear from you.
Kevin?
I'd say ask questions. It's brand new for everybody here on this call. It's brand new for everybody on this state. If you don't know the answer to a question, don't guess at it. If you need clarification, did you see something from the deed website? Ask one of us or another professional in the industry. You're not wasting any of our time. I think I can speak for the other two saying or the other three, you're not wasting our time by asking us the question. We're here to help you navigate this new mandate together. I'm a small business owner. I'm in the same boat as all of you, and I'm learning new things every day, right? The state keeps coming out with adjustments, and we keep reading new things on their website. So please reach out. Happy to help with whatever we possibly can.
Nate?
I guess I would echo, what Kevin said, that this is new for everyone in Minnesota, and there are a lot of questions. There are a lot of parts of this law that are going to take some time to get used to. There'll be answers that professionals like us don't necessarily have until we get into this next year. And there's experiences that we can draw from because people have gone through them. The law is out there, and we can do our best to try to, provide what we can in terms of guidance about compliance with it, but it will take time. But I would just remind people that this is not a time off necessarily a time off law. This is a benefit law. This is a program designed to benefit employees who take time off for qualifying events. And so the contributions that are being put in are being shared by both employers and employees in most instances, of course, unless an employer opts to pay 100% of the coverage for the employee. But it's a benefit program to be paid while you're gone. And I would just try to remind people that that's what it's designed to do.
So as a reminder, in our Monday e-newsletters for the chamber, we do send out updates that we receive from Deed with links and resources. So please be sure that you are reading that. We have a special page for our employers on our website, MetroNorthChamber.org. And don't hesitate to reach out to the chamber directly if you have specific questions, and we will do our best to get you answers. So thank you all for being here today. We really appreciate your engagement and interest in getting this program set up for your business and getting your questions answered. And we will get this recording out in the near future, along with some of the other resources we talked about. So thank you all and have a great day.
Thanks, everyone.
Thanks.